I'm George Whipple. Welcome to the show. Here are the top stories in employment law from February 2019. We begin with the Supreme Court, which remanded an important equal pay case back to the Ninth Circuit last week. The High Court vacated the decision due to the death of the ruling's author, Judge Stephen Reinhardt, before the decision was announced. The move temporarily relieved the circuit split on whether salary history could be used to justify a pay disparity under the Equal Pay Act. New grooming policy restrictions in New York City. The city's Commission on Human Rights has released new legal enforcement guidance protecting the rights of workers to wear their natural hair and hairstyles. David Garland, member of the firm for Epstein Becker Green, is here with more details.
The Commission issued guidance that impacts employer policies restricting certain hairstyles in the workplace. And the Commission specifically was concerned about the impact of those policies on black employees. What's important here is that even facially neutral policies, that is, policies neutral on their face, that may have a disparate impact on black employees, may violate the New York City human rights law. In view of the recently issued guidance, it's important that employers review their grooming and appearance policies to ensure compliance with the guidance.
And some follow-through on tip credits from the Department of Labor. Last year, the DOL released an opinion letter rescinding the 80-20 tip credit rule, which prohibited employers from taking a tip credit for workers who spend more than 20% of their time on untipped side work. The acting administrator of the Wage and Hour Division has now updated the division's Field Operations Handbook to remove any mention of the rule. Workplace gossip can, in some cases, violate Title VII of the Civil Rights Act. That's according to a recent opinion from the Fourth Circuit. In Parker versus Rima Consulting Services, the defendant, who had received multiple promotions, discovered false rumors circulating that claimed she had slept her way to the top. A senior manager helped to spread the rumors and shut the defendant out of related discussions. The Fourth Circuit found that the sex-based nature of the rumors implied that she used her womanhood rather than her merit to obtain the promotions, and thus the rumors violated Title VII. And finally this month, an increasing number of HR teams are enjoying the efficiency and effectiveness of artificial intelligence as well as the significant cost savings. But the use of AI technology can also create new legal risks.
It's important that employers don't blind themselves to the legal risks that are inherent in some of the AI processes that are available. And that means making sure that disparate treatment and disparate impact claims and the potential for those claims are limited in conducting an early review, and also making sure that people with disabilities can be accommodated and they can be treated equally when they're evaluated by these AI technologies.
Thanks, Nathaniel. Now, private HR consultant Garland Capelli joins us with some tips on alternative dispute resolution, or ADR, programs.
There is no one-size-fits-all ADR program that would be suitable for all organizations. There are a number of factors to consider when actually drafting an ADR program that is best suited for your needs. The first thing to consider is, what do you actually have in place now that is effective in resolving conflicts, or at least helping conflicts not to escalate to a point where an employee files a claim or actually seeks out a third party? If you do decide you want to pursue drafting an ADR program, it would be helpful for you to take a look at what type of conflict has occurred within my organization over the last 12 months, maybe 24 months, or maybe 36 months. But most importantly, what you need to think about is what goal are you trying to achieve when establishing an ADR program.
Thanks so much, Geraldine, and thank you all very much for watching. We'll see you next time.